Hello everyone, and welcome to our Women in Sectional Title webinar. It's 11 o'clock on the dot. We aim to inspire you to grow, to learn, and to share all the information, all this foundational information with your trustees, owners, or fellow portfolio managers. From what we can gauge, we have 222 registrations for this webinar, which is fantastic. It's a record for us. And out of that 222, probably about 90% of you are portfolio managers looking to gather information and to take it out there into your workplace. So we really appreciate that. We've also had quite a lot of interest in our Women in Sectional Title template rules. So if you go onto our website, you are able to look at obtaining a set of template rules at a fee. And those rules you are able to tailor make for your body corporate. We've managed to ensure that we've got everything in that set, so you can leave out what doesn't apply to you. And we have found it quite valuable and useful, so bear it in mind. Of course, it goes without saying that we are thanking our brilliant sponsors, without whom this platform would certainly not exist. So Sectional Title Solutions, We Connect You, and PK of Octagon, thank you very, very much for this opportunity. And I would urge all of you to go and have a look at the websites for these phenomenal companies and businesses. Women in Sectional Title, we are really quite choosy about who our sponsors are, and we would not surround ourselves with people that we don't trust and that are not relevant and contributing to our precious sectional title industry. So thank you so much for that. Right, today's quite a bit of interest, and we are looking at fines and penalties in sectional title complexes. I'm just being fed, and we've put it up here. And we're thinking the truth about fines and penalties, and we're looking at fairness, enforcement, and the law. I think it's such an interesting topic because it affects the back pocket of so many owners. So let's just dive straight in. We will look at questions later. Oops, let me go back, sorry. Can't see what's going on here. Okay, there we go. So the introduction and objectives for today, we're going to cover the historical context of fines and penalties, the South African legal framework. Of course, we must look at moral and practical considerations. We'll briefly touch on international jurisdictions. And then later on, if you want, we can talk about a couple, if we've got time, some questions and answers. So let me tell you straight off the bat, I am not, and I wasn't originally pro fines and penalties in complexes. I wasn't in favor of them. And I'll tell you the reasons why. The fact of the matter is, I always thought that when you live in a complex and you're trying to create this harmonious environment, it becomes exceptionally tricky when you're imposing monetary punishment, monetary form of punishment on people. All of a sudden, the dynamic changes in the scheme. And things, aren't quite as happy because, again, you're dealing with people's money. And I'll never forget receiving a telephone call from Tertius Moret, who was my colleague in Cape Town, in Stellenbosch. And I remember him saying to me, Marina, we've got differing views on fines and penalties in complexes. And I think we need to have a chat about it, because I do think that we have to look at placing these kind of clauses into our rules, and they should become enforceable, and we need to put our minds to how to do that. So I remember going through to Stellenbosch at one stage and going to visit Tertius, who I must say I miss tremendously. He was a great force in our sectional title industry. And Tertius and I sat and chatted about it, and we looked at ways where you could place the fines and penalties clauses into the rules, but obviously with certain very, very strict conditions. I'm still not fond of fines and penalties in sectional title. I've seen the very bad side of things, and I've seen the abuse that happens in our complexes as well. But I think it's naive to think that these things aren't necessary. And that's why we're going to look at them more carefully now, right? So Why fines and why penalties? Well, it seems quite self-explanatory. Obviously, the purpose is to enforce rules, to encourage compliance, to avoid repeated misconduct, although again, in my experience, that's often not the case. And when we look at the CSOS mediations and contraventions in terms of their financial statements, we look at things like noise nuisances, parking violations, and pet-related issues as the most serious sort of contraventions which attract fines at the moment. What is the difference between fines and penalties? Well, if you look at Kenrock Homeowners Association versus Allsop and another, we see here that a fine is a one-off amount levied for breach, and a penalty is a normal monthly levy doubled or tripled and charged per month. Penalty is obviously more punitive, and we don't like the word penalties actually when you're looking at your rules later, because we've got certain limitations on charging more than the levy, and you'll see that a little bit later. Oh, sorry, I'm really not doing well with it. Okay, so legal foundation that we need to investigate here. Let's just go back to the historical context. The early body corporate structures. Pre-Sectional Title Schemes Management Act 8 of 2011. So we had the 1971 Act. We had, that was in the early stages. And if you look back on that and you think, geez, sectional title is actually quite young. If the first act ever came out in 1971. And then you go a little bit further to the 1986 Act. There was never clear legal authority for the imposition of fines. You had some trustees deciding to put fines into their rules, but there was nothing explicit in any of that legislation which gave rise to fines and penalties. And because of that, many of the legal authorities were involved in big debates around the enforcement of something that is not legislative and that the trustees are simply imposing in their rules. Then we look at the common law versus the legislation. Also in our common law, when we don't have something in legislation, we fall back on common law. And the common law also had nothing explicit to say about imposition of fines and penalties. It was quite clear that there couldn't be arbitrary imposition of penalties and fines on anything. Anything which was imposed on people, this is just in a general context, not in community schemes, shouldn't be disproportionate to the contravention, certainly. And there isn't inherent right of anybody to actually impose a fine on anybody else, unless it's in an agreement or unless it's in a contract. So that's the first kind of indication of where we're going with the fines and penalties. When I say the wild west of fines, well, at the end of the day, yeah, at one stage, it was a little bit crazy. If you looked at when we were practicing, 15, 20 years ago, trustees would simply put two sort of paragraphs or even a paragraph saying that the trustees have discretion to impose fines in the case of contravention of these conduct rules. And they wouldn't even say how much the fines should be. They would impose ridiculous fines, amounts of fines, and it would be very much a thumb suck, and it wasn't carried through consistently throughout. And of course, it led to an abuse of power, and this is what led us to stricter rules being imposed. So if we're looking at the legal foundation now, we're looking at a couple of acts which may or may not have had an impact. So we start with before 1971 with the Conventional Penalties Act 15 of 1962. And that was the act that I used to say, no, you can't impose fines because there's no contractual basis between the rules and bodies corporates in any case. And that Conventional Penalties Act, like a 2-page act, basically, though, what you can draw out of that is that it does say that you can only impose fine by agreement or by way of a clause in a contract. So that's again, very wishy-washy. Then something that's also been raised quite recently is the Promotion of Administration of Justice Act, PAJA 3 of 2000, which has something to do with fines. And administrative law is actually of critical importance. So where there's power exerted by officials or by, group in charge of an administrative body, you can apply in terms of this act to have any administrative decision reviewed. So a lot of people were coming up with the idea that and especially before the community scheme ombud service came along, that you could review fines and penalties which were imposed. That was the route to go if you felt that these were unfairly imposed upon you. But we have learned since then, through case law and just through common practice, that in fact decisions by community schemes are not regarded as administrative by nature, and therefore the Promotion of Administration of Justice Act does not apply, and you can't actually go ahead and review these decisions. All right, then we come to the Sectional Title Schemes Management Act. Of course, we know that, we've become comfortable with it. That's Act 8 of 2011. We've referred to it before. And again, no express provision for fines. Nothing in the Act, nothing in the management rules, and your conduct rules, we've realized, can allow for fines. We understand now that we can certainly, with very, very strict provisos and conditions that we'll go through a little bit later. And we'll work out how exactly you get those fine clauses into the conduct rules. And of course, you've also got the Community Scheme Ombud Service. The Community Scheme Ombud Service is the regulatory body that regulates, we all know, that regulates our community schemes. And we're going to look to see how the Community Scheme Ombud Service relates to fines and penalties. I've put the undesirable rules in Consolidated Practice Directives 1 of 2025 because we can have a look at what it says about fines. I don't know if all of you have got this. So this is the consolidated printed out version of the Practice Directives 1 of 2025. So they've taken all the practice directives and put it into one big, thick document over here, which is actually fantastic. I spoke to the Chief Ombud yesterday, and she confirmed with me that this is a draft still. This is a draft, and they should be looking at having something more finalized first or second week of May. So those are your practice directives. They were open for comments. I think you had until the 4th of April to comment about them, but we will be looking at what they say about fines and penalties. Of course, then we have the moral and ethical considerations around fines. Fairness and equity come into play in a very, very big way. And again, the Community Scheme Ombud Service will always look at fairness. Is it fair? We also have the words reasonable, which will pop up later. There's always a potential abuse of power in these situations. We have to have transparency and communication about fines and penalties. Don't ever ambush people with them in your rules, which you can't do anyway. The modern form of is against the sort of modern form of justice is against punishment. It's more about rehabilitation of people in complexes, which, as you all know, is easier said than done. And we know now fines and penalties in terms of one of those directives may not be equal to or more than the applicable monthly levy of the unit. And that is something to consider. A lot of managing agents still don't know that. And I think it's going to cause very, very big problems, and for these kind of clauses to be kicked out as invalid by the CSOS. Your key global trends, if we look around, the process of putting these clauses into place and fining people has to be fair. There need to be legal boundaries around the disproportionate amount versus the contravention or the contravention itself. And of course, mediation. And mediation is very important at this stage. Even in our courts, I must tell you that we've got new laws now around mediation, where before we go to litigation, we've got to satisfy the court that we have tried other methods and tried to mediate, similar to the community scheme Ombuds Service dispute resolution. So even if you're taking a huge matter to the High Court, we need to try to mediate, and they're going to start making that compulsory because the courts simply don't have the capacity to look at all the court cases. I mean, the lawyers on screen will understand that we're only getting court dates for 2-3 years now, onwards, becoming very, very difficult. Okay, let's go back to conduct rules and fines. So the one thing again, so many people get wrong. Trustees do not have the right to unilaterally decide on amounts of fines and penalties. What has to happen is the body corporate needs to have sight of what fines are contemplated, and at every AGM, I would always say that you need to review that and give permission again in your minutes to say yes. This is the schedule. The Community Scheme Ombuds Service is not interested in just, sort of not mentioning amounts. You have to put the amounts in your schedule and the contravention to which that amount relates before they will even consider that it's worth anything. Fines must be based on registered rules. Yes, that actually goes without saying. So if you amend your rules and place fine schedules in, you would need your compliance certificate from the Community Scheme Ombuds Service. And of course, the service will also become involved in telling you, well, I don't think that's reasonable, or that fine is really over the top, and that's not good. Must be reasonable and proportional. Well, who's to say what is reasonable? Again, the law would bring out that reasonable man test. The reasonable man test will look at what a reasonable man or woman in the position of the trustees would place as a fine. So it brings in the legal test for reasonableness, which is objective, it's not subjective. You must follow due process. And of course, the CSOS circulars emphasize fairness at all times. How to introduce or amend fining rules. So the rules would obviously be the same as any other rule that you want to introduce. The rules must be specific and fair, and we've said specific, so specific that it has schedule. We've got schedules attached to rules that are 2-3 pages long sometimes. And I think you would obviously need to draft your rules. With your new rules, you would send a notice to the owners, giving 30 days notice, because it's a special resolution where you have to amend your rules. Once you've received a special resolution at your meeting, that's 75% in number and value, you would then take your rules and submit them to the CSOS in the correct format with the correct forms attached, and obviously they must be initialed by at least 2 trustees on each page. We do that regularly, submitting amended rules to CSOS, and they must align with the Community Schemes Ombuds Service Directive. Okay. Importance of due process, again, warnings must always precede fines. The contraveners must always have an opportunity to respond and to be heard. And that was, in those days when I went to Tertius, that was something that was incredibly important. You have to have the right to be heard. Trustees must be consistent and unbiased in their decisions, and unlawful fines can be overturned by CSOS. So I would like to take a break here just to look at, and you can just write this down, because while I was dealing with this, I had a look at it. The CSOS Act, Community Schemes Ombuds Service Act, Section 39(3)(d). Something that we don't always realize is that these rules, and especially the fine clauses in these rules, are not carved in stone. They can always be looked at by the Community Scheme Ombuds Service. And what it says in respect of scheme governance issues, the Ombud can always, and this is the D, give an order declaring that a scheme governance provision having regard to the interests of all owners and occupiers in the community scheme is unreasonable, and requiring the association to approve and record a new scheme governance provision. 1, to remove the provision. 2, if appropriate, to restore an earlier provision. 3, to amend the provision. Or 4, to substitute a new provision. So I think this could be utilized a lot more when you take matters to the Community Scheme Ombud Service. Rules are, there not to be broken, but certainly to be challenged. So if owners are not happy with certain rules, that they do have the remedy and relief. And I have seen many awards where the amount of the fines have been reduced by the Ombud. So that's important. Now, the CSOS draft directive that I was talking about says that you should have this particular information included in your fines and penalties clause. So, first transgression notice. Let's see, in writing to member or occupier, so it's got to be in writing, it's like a letter, like a warning letter. You've got to explain the transgression or the offence in the first notice, advise them to stop, give them a time frame within which to stop, and tell them that they are able to dispute the defence and to meet with the Board of Trustees. No fine may be imposed in the first warning at all. Then you get the second transgression notice. It must also be in writing to the member or occupier. Explain the transgression and how it relates to the same offence as the first offence and what date you sent the first warning. Advise them to stop. Also give time frame. The member or occupier may again dispute the offence and meet with the Board of Trustees. And the fine may be imposed at that particular stage. Okay, so let me just go to the chat group. Sorry, I just want to have a look to see if there's anything. Nola says, in my scheme, the managing agent charges 200 Rand for the first warning letter. Then there is the fine of minimum of 200, 250 on top of that when a second letter is sent. Okay, I understand that it's base class says to have a schedule of contraventions fines presented at the AGM. However, I've seen CSOS certified conduct rules leaving amount of fines at trustees' discretion. Yeah, I've seen that. That's not good because the CSOS is quite adamant about that at the moment. Natalie Peter says we're very poor AGM attendance, so we have no feedback on the rules. Our CSOS approved rules state the amounts or percentages of the levies to be charged for specific contraventions depending on the severity. Warnings issued first before any fine imposed. Linda says we are the managing agent who charges for the letter warning, so they don't call it a fine. It's a charge for the letter. Is this allowed? Well, of course, that all depends on what your contract says with your owners. Obviously, if it's a reasonable admin charge, then I would probably say that it is okay. Right, let's move on. Education and awareness, things like these are alternatives to fines. And again, the whole world is going towards trying not to impose monetary fines on people. So it's about education and awareness. It's about mediation and resolution again. Rather do warning letters and rather try and take things to the Community Scheme Ombud Service before escalation. That's often quite difficult. I know that there's still delays with CSOS, but we are eternal optimists, and we hope that we can move faster with the CSOS adjudications, especially. Then there's something called restorative justice. So restorative justice is a criminal law term. And it's when a criminal has, committed a criminal offence, and now instead of going to jail, they look at restoring balance with the victim type of thing. So this is something that is being looked at overseas, but I'm not too sure how it would work in community schemes, because that would mean kind of getting people to do almost a community service within schemes to show how sorry they are. So if you get a guy who's constantly hooting in a complex, instead of fining him, you can make him do the garden. I don't know how far that can go, certainly being investigated at this point. So we'll see about that. Okay. Let's just go back here, right? Then for managing agents, trustees and managing agents, first of all is to review the rule compliance and request owners to approve the specific fine amounts at every AGM. I know that's very difficult, but that's a very good thing to look at doing so that you've got it on record and keep those records. Obviously, it's to educate the community and to seek legal advice as well, if you need to seek legal advice. Okay, then we go on to international jurisdictions. If you look at the United States, we've got homeowners associations definitely use fines to enforce the rules. Fines must usually be authorized by the homeowners associations governing documents and follow due process. Example, a warning notice and the right to a hearing. States like California and Florida have detailed laws regulating fines to prevent abuse. In Australia, I know the owners' corporations, which are similar to our body's corporate, can impose fines in some states like Victoria and New South Wales, but enforcement typically involves applying to a tribunal like VCAT, which is the Victoria, I think it's a civil administrative tribunal for an order. Fines are more limited and usually need adjudication rather than being imposed unilaterally. United Kingdom, we've got leasehold properties in the United Kingdom, so no sectional title, but penalties for breach are often handled through service charges or tribunal processes. There's no blanket legal right for a management company or residents association to fine leaseholders without formal legal proceedings. Alternative approaches such as mediation and injunctions are preferred. Then in Singapore, management corporations can issue fines for rule violations, but only if the rule is registered with the Building and Construction Authority. A fair and transparent process is followed, and disputes are handled by the Strata Titles Board. In Canada, especially in Ontario and British Columbia, there are, you may issue fines or chargebacks, they call them, but this is controversial. Many boards prefer to seek compliance orders through tribunals instead of unilaterally issuing fines. So you can kind of see trends that we're looking at. Okay, now I've given you an example here of an unenforceable conduct rule. So that starts off by saying, and this is actually, I obtained this from one of the managing agents that I deal with probably about 3 weeks ago. And I'm a bit concerned about what is being done in this complex. So what it says is, it starts like this. With a change in the social fabric of the complex, in terms of increasing occupancy. Sorry, let me just take that off. It's in my way. Oops, hold on, sorry. It's imperative that the trustees ensure that the body corporate enforce the rules as prescribed in the Sectional Titles Act. A lack of enforcement of the trustees may lead to anarchy reigning supreme, which will ultimately decrease the value of your investment. In essence, owners, occupiers, and tenants are reminded that they live in a community environment and that all residents have the right to harmony, peace, and quiet. Furthermore, all owners are to ensure that the conduct rules are applied in accordance to the rules set out and registered in the deeds office. Any person persisting in breaking any of the rules, including disruption, disturbing the peace, inconvenience to owners and occupiers, and in defiance of the trustees, will be liable to a fine as per Annexure A. The penalties imposed will be automatically included with the owner's monthly levy statement. Okay, that's something we must also discuss. Okay, don't like the words "and in defiance of the trustees." I mean, that does not set a good tone at all for a very good relationship. And I would, if I was checking these rules, I would whip that out, chop, chop. Okay, so these rules, we're still talking about these rules, and they say in the rules, the procedures to impose the penalties are as follows. 2 written complaints received from any owner or occupier to either the trustees or the managing agent. 1 pre-warning letter from the managing agent to refrain from the transgression to the owner. If the transgression persists, the body corporate will implement the penalty fee as indicated under the first penalty column. Further transgressions will attract further penalties under the second and third penalties column, respectively. The complaints received will be valid for 12 months and will be filed with the managing agents. Okay, so what is wrong with this? No right to be heard. It's not giving anybody a certain time period to contact the trustees or whatever the body corporate puts in place. But there needs to be that right to be heard. They can ignore it, that's fine. But if it's not there, this is not a valid rule. You wouldn't be able to fine, and you'd have to take those fines off any account. Okay, so let's look at Annexure A, because it's quite interesting to see what people are charging these days, and I'd like your comments on that, please, if you'd like. This is quite an interesting one because they're charging a proportion, because the managing agents have become alive to the fact that you can't charge more than the monthly levy. This managing agent suggested a percentage or a portion of the monthly levy. So let's have a look at it. Illegal and or non-approved installation of air conditioning units. The first penalty is 1/3 of the monthly levy. The second penalty is 2/3. Alterations, extensions to units and solar system installations obviously without permission, also 1/3 and 2/3. 3, damages, alterations or addition to the common property. Also 1/3 and 2/3. So they keeping very consistent here. Tampering of fire equipment, 1/3, 2/3. Unlawful activities on common property in terms of constitution. Okay, I don't know what a constitution is. That pertains to homeowners association, but there you have it. And noise disturbance to the peace, that also draws that. Have a note, have a look. The third penalty is just 50 rand less than the monthly levy, just to keep in that monthly amount. I'm not sure how many of you do this. Refuse disposal and littering on common property also for the same penalty. Security, any action that undermines or shows disregard to their authority and responsibility. Same thing. I must just add here, we're getting a lot of complaints about abuse of security guards at the moment. And I think trustees and managing agents need to deal with that in quite a robust way. Speeding over 20 kilometers per hour. Yeah, that's also, that's subject to a number of cases. I'm sure you're aware of the case law regarding speeding in complexes, storage of inflammable material, illegal parking on common property, blatant disregard of the conduct rules as prescribed by the trustees, which is not stipulated under this annexure, and failure to comply with rules pertaining to parking. Parking is definitely very, very high up on the agenda there. So, the thing with this is that if you've got your levy, if you've got a high levy and you're living in a nice complex, this is high. These amounts are too high. I don't know if you agree with me. But this would work out to be like just under 2,000 rand for first transgression if your levies are sort of over 4,000 or 5,000 rand. I think that's too high. Let's see. Sheil says, if a general letter is sent out to all the owners informing them that this notice serves as a first warning, itemizing various possibilities, example, playing with balls against the wall, can the next letter sent to the particular owner be considered as a second warning? No, definitely not. You would need to personalize that first warning to that convener. What happens, Paul says, what happens when you have an Airbnb and the occupant changes weekly? Is the owner responsible for the warning and fines? Yeah, well, I think that's going to be a difficult one because if your complex says that there are no Airbnbs allowed, you would need to just do, you would need to do one-off fines. Unless it becomes a situation where now it becomes a bit more punitive and you have to impose a monthly levy that's just consistent because it just keeps going. It's an interesting one, Paul. I have to think about that a bit more carefully. Michelle says, sorry, this is a long one. I'm having a big problem at one of our properties where the registered rules are missing pages. Trustees are trying to update the rules to include fining. However, the owners would be fined as they constantly break the rules on purpose, and it's just a coincidence that the amount of those owners who are opposing the rules have not passed the changes by a round robin because they don't want to be fined. We've asked CSOS for a resolution to amend these rules so that we can start fining those who continuously break the rules. Such a nightmare, having to go through the route of imposing costs, etc. But they're refusing to pay and saying that the charge is illegal. Well, that is quite a mouthful. I'm just looking here. So if you look at the Community Scheme Ombud Service Act, Section 39(3)(d), it says that the CSOS can actually give an order requiring the association to record a new scheme governance provision. So that is something that you can ask the CSOS to add, and if it's in compliance with their directives, I think that you would probably be successful there. Natalie Peterson says the third penalty sounds quite excessive. Yeah, I agree. And Diane says, is this not discrimination for the same transgression where levies vary? Yeah, I suppose you could definitely raise that. I think that's right, Diane. Okay, Clive says the managing agent contracts with the body corporate, so to charge for a letter to defaulting owner may charge a cost to the body corporate. Unsure if this is then legal to recover this from the default on their levy account. Yeah, you wouldn't be able to recover it from the defaulter on their levy account. Absolutely not. Let's just talk for a moment about placing fines and penalties onto the statement, onto your normal levy recon, your levy statement for your owner. So let's look at, well, that brings us to the management rules here. If I can just read to you. So we're looking at management rule 25(5), which says the body corporate must not debit a member's account with any amount that is not a contribution or a charge levied in terms of the Act or these rules without the member's consent or the authority of a judgment or order by a judge, adjudicator, or arbitrator. So, this is a situation where, like, we collection attorneys, so we'll get a recon from our managing agent, and the recon's got all sorts of charges on which are not legal. Can you put penalties and fines onto this account? All right, let's look at it more carefully. The body corporate must not debit a member's account with any amount that is not a contribution. Okay, so this is not a contribution, or a charge levied in terms of the Act or these rules. And when it says these rules, it's in the management rules, it's not in the conduct rules, without the member's consent or the authority of a judgment or order by a judge, adjudicator, or arbitrator. So in the very strict sense of the word, from the interpretation of this clause, you could deduce that you're not allowed to place penalties onto owners' accounts. You would have to charge them separately. If by these rules, in here, it talks about management or conduct rules, which you can also interpret it to mean, it's a differing opinion. And if it is in your conduct rules that you can charge and they're reasonable and it's all according to the CSOS directives, then I think you would be able to place the penalties onto the accounts. I'm not sure what other people think, but certainly it's very interesting to look at. Let's just see this one. Butch says, warnings and subsequent penalties are directed at the owner and not the tenants. It's up to the owner to take it up with the tenants. Therefore, irrespective of the change of tenants from week to week, it has to be treated as if it's a second warning or subsequent penalty against the owner. Yeah, 100%. Okay, let's go on now. Okay, then this is another body corporate. I've just looked at the expenses and the amounts here. So let's go through this one. Parking of vehicles illegally That's a warning, and then it's a second offense. First offense is a warning. Then you've got a 250 rand and 1,000 rand. It jumps up to 1,000 rand. I don't know, 1,000 rand to me seems very high in this. I don't know, 250, 500, that seems better to me. I don't know what you guys think. Storing of trailers on common property, 250 rand. And then there's another 500. Hanging of washing on windows, walls and fences, 250 goes up to 1,000 rand. Speeding is 500 rand and 1,000 rand after the warning. Storage of non-garden furniture on balconies, patios and gardens, up to 1,000. Not stopping at gates and tailgating, 1,000 rand. Hooting is only 250, and that's on the third offence. So hooting is not big in this complex. Littering, also 500 and 1,000. And if you go down right to the end, not adhering to security protocols in this complex gets a big no-no, and that is 1,500 rand. Or your, well, they say third offence. It's actually second, because you've received a warning. So here there are warnings, and there is the need for warnings. Okay. Are there any other questions at this stage that you need me to? You can actually come online if you'd like. If you've got a question at this stage, you can come on and ask. No questions. One thing I wanted to say to you, and I was speaking to a secretary of mine who actually does quite a bit of work in one complex. Something that's important to note, please, is that a building can get a very bad reputation in terms of the way they're imposing unreasonable fines. In fact, in this very large estate in Gauteng, we've heard of a few people who are not willing to buy into the complexes because they reckon that it's a little bit draconian in terms of what the trustees are doing in the complex. So always bear that in mind. The other thing I wanted to tell you, one of the last things I want to tell you is that building penalties for building work in complexes in the big estates, like the new developments where you've got people who are not complying with how they must build, and they're taking too long and they're delaying things. The courts here, I know there's a case called Bella Rosa 3 versus Brand, was in the Western Cape, where the court got involved in saying that the building penalty was unreasonable. In that case, it was 10% of the purchase price. So after 30 months, if you hadn't built, you would be charged every month, and it would be 10% of the cost of your property, which is actually works out to close to, I think it was 20,000 rand a month until you start building. So these things also, speaking to the management at the Community Scheme Ombud Service, they don't like these building penalties in new schemes. And I think they're looking at more and more of them and taking out those clauses in either the MOIs or the body corporate in the rules. Okay, so when sectional title living gets too creative, I thought we needed a good laugh. So let's have a look at this. Asked AI a few things. I asked AI to help me here. So the AI got a few interesting contraventions. Hanging bright pink underwear on balcony, 500 rand. Splash of color and controversy. Midnight braai in the common area, 1,000 rand. Neighbors reported the smell as unreasonably tempting. Yorkshire Terrier digging escape tunnels, nicknamed Shih Tzu, and that was also quite a large amount. Diagonal parking over 2 days, 500 rand. Chalk outlines left as guidance. Skinny dipping in the communal pool, 1,500 rand. CCTV mysteriously deleted. Feeding birds from the balcony, 1,000 rand. Attracted a monkey, body corporate unimpressed. Balcony Weber fire, ceremonial flames, 800 rand. Smoke was very much not symbolic. Emotional support chicken in flat, 1,200 rand. Named Cluckles became a regular at meetings. Selling the gate code to delivery drivers, 2,000 rand. Community outreach claimed by the resident. And spray painting bins with slogans, 600 rand. Waste not, want not, both literal and ironic. So yeah, that gives us a little bit of a laugh. And I have seen over many years, many creative rules and certainly many creative impositions of fines as well. I hope that helped you to put in context where we're going with fines and maybe to give that kind of advice to owners, your owners in sectional title. We've come to the end of our webinar, and thank you again to our sponsors, We Connect You, Sectional Title Solutions, and PK Octagon. Absolutely fabulous. We appreciate you. And yeah, if you've got anything to add or anything that you want to send me about fines and penalties and you want some answers, I'm very, very happy to get back to you. Thank you so much for joining. And yeah, I think we'll see you next time, hopefully, at our May webinar. And until then, take care. Thank you.